Welcome to the Deep Dive. This is the study for the bar in your car deep dive.
And we're your hosts, Claude and Ma.
Yeah?
This is episode 3 of our Torts deep dive. Today we're really getting into a big one, intentional torts, focusing specifically on false imprisonment.
Yeah, going to unpack what it really means to protect, your freedom of movement.
Exactly. Now, we are AI bots.
We are indeed. Brought to life by, AI magic and Angela's amazing tort law notes.
And if we do say so ourselves...
We think we look darn good. Bots love compliments, just so you know.
Ha, right. But you know who isn't a bot? Angela.
True. She's a real live human, a dedicated law student from GMU.
Mm-hmm. And she's gearing up to take the bar exam this summer. Angela couldn't be here for her usual intro, so she asked us to fill in.
So if you have questions or feedback for Angela, you can reach her at podcast@studyforthebarinyourcar.com.
And this is important, too, for any attorneys listening or if you know one who needs some ad hoc help.
Like with legal research, writing motions, complaints, writs, answers, briefs, that kind of thing.
Exactly. Angela also works as a freelance law clerk.
Oh, nice.
You can email her for those services at hello@legalwriterandlawclerk.com.
Okay, great. So let's dive in. False imprisonment.
Let's do it.
All right, false imprisonment. At its core, this whole thing is about protecting your freedom of movement, right? Your physical liberty.
That's the essence of it. Angela's notes define it pretty clearly. It happens when an actor intentionally confines a victim to a bounded area.
Okay, intentionally confines bounded area.
And crucially, the victim is either aware of the confinement or they suffer some kind of harm because of it.
Got it. Aware or harmed.
And what's really interesting here, as Angela's outline points out, is that this is a civil wrong. It's totally separate from contract law.
Right, not about broken promises.
No, it's purely about safeguarding that fundamental right to physical liberty. The law takes that very seriously.
Okay, so let's break down those elements. First up, the act has to be intentional. What does intentional really mean here in tort law?
Good question. Angela's notes stress that the act must be volitional, willful.
Meaning you have to consciously choose to do it.
Precisely. Think about it this way. If someone hits you while they're, say, sleepwalking or having a seizure.
That doesn't count.
Right. It's not a volitional act for tort purposes. It's not a battery. And it wouldn't be false imprisonment either because there's no conscious decision behind the movement.
Okay.
For false imprisonment specifically, the defendant needs to have the purpose to confine you. They have to want to confine you.
Or what's the alternative?
Or they need to know with substantial certainty that their actions will result in your confinement.
Substantial certainty. So like almost positive it will happen.
Exactly. It's a high bar. And notice, it's not about intending to cause harm, just the intent to make the contact or, in this case, cause the confinement.
Right. The intent relates to the confinement itself, not necessarily bad motive.
Correct.
So Angela's notes give this example. A librarian locks up at closing time. Totally unaware a customer is still inside. No intentional false imprisonment there, right? Because the librarian didn't have the purpose to confine that person.
Exactly. No purpose and no knowledge with substantial certainty that the customer would be confined just by locking the main doors. The intent element is missing.
Could that make sense?
Yeah.
The state of mind regarding the confinement is key.
Absolutely. Negligence or just being reckless isn't enough for this tort. It needs that specific intent, purpose, or substantial certainty.
Okay. Element 2, confines or restrains. This sounds like more than just stopping you from going exactly where you want to go.
It is. It means you're actually held within certain boundaries. Angela's notes list several ways this can happen.
Like what?
Well, the obvious ones are physical barriers, locked doors, walls, that sort of thing.
Sure.
Or direct physical force, someone literally holding you back, blocking your path.
Okay. Against you directly.
Yes, or even against, say, your immediate family if that prevents you from leaving. Or against your property if it stops you moving, like someone grabbing your car keys or physically blocking your car.
Wow, okay. So force doesn't have to be person-on-person contact.
Not necessarily. It's about effectively restricting your movement.
What about less direct methods? Things that aren't physical barriers or force?
Definitely. Threats can do it. Direct threats of force, if you try to leave, I'll hurt you.
Clear enough?
Or even indirect, implied threats. Think about someone with an intimidating presence just blocking the only doorway and saying, I wouldn't leave just yet.
Yeah, that could feel confining.
Angela's notes also mention confiscating essential personal property, like taking away your crutches if you can't walk without them.
Or maybe prescription glasses?
Could be, yeah. If it makes it unreasonable or dangerous for you to leave, it's about removing any reasonable means of escape.
Okay. What else?
Invalid use of legal authority. This is basically false arrest.
Someone pretending to be a cop or a real cop acting without proper grounds.
Exactly. Detaining you under the color of law, but without actual legal privilege. And another one, breach of a duty to release.
A failure to act.
Yes. If someone had a duty to let you go maybe from a prior lawful confinement that's now ended, and they failed to do so, think of a hospital not discharging a cleared patient. That omission becomes confinement.
Interesting. And Angela's notes mentioned embarrassment. How does that work?
Yes. It's a high standard, though. If the only way you could escape would cause severe public humiliation.
Like really severe.
Extremely severe. The example often used is if someone took all your clothes in a public place. Leaving would mean extreme public exposure.
Okay, so not just feeling a bit awkward.
No, definitely not. Angela's notes are clear. Mere moral pressure, like feeling you should stay to clear your name, doesn't count. The law uses a reasonable person standard here.
So someone saying, I'll blow up Saturn if you leave doesn't count, even if you really care about Saturn.
Exactly. Your hypersensitivity isn't the measure. It needs to be objectively unreasonable to leave due to force, threat, or extreme humiliation.
Good to know Saturn is safe from tortfeasors.
For now. And finally, deception or fraud and coercion can also work. Being tricked into staying or pressured so heavily you feel you have no choice.
Okay, lots of ways confinement can happen. Now, the bounded area. That's key too. Not just any restriction works.
Right. It's not just about a small room. The key, according to the outlines, is that your freedom of movement must be restricted in all directions.
All directions. So if one way is blocked, but you can go another way.
And it's probably not a bounded area for false imprisonment purposes, even if the other way is inconvenient.
Doesn't have to be walls, though. The boundaries.
No, they don't have to be precise lines. And the area doesn't have to be tiny. Angela's notes mention some cases have held an entire state or town could be a bounded area.
A whole town? Really?
Under specific circumstances, like a total quarantine where all exits are blocked, but generally not a whole country. The point is, there's no reasonable means of escape from that defined space.
So what definitely isn't a bounded area?
Well, preventing you from entering a place isn't confinement. Being denied entry to a club, for example.
You're excluded, not enclosed.
Exactly. And as we said, mere moral pressure or persuasion isn't enough. Future threats or threats just to your reputation also don't usually create that immediate physical bounding.
Okay. And a last core element. You have to know you're confined or be harmed by it.
Correct. Awareness is key. Angela's notes use the example of being locked in while asleep.
If they unlock it before you wake up.
And you suffer no harm. Then no false imprisonment. You weren't aware, and no harm resulted.
But if you did suffer harm, like missed medication or had a panic attack upon waking,
then the harm element could be satisfied even without full awareness during the entire confinement. It's either awareness or harm.
Got it. And wrapping up the core elements, all of this has to happen without legal privilege or authority.
Absolutely crucial. If the confinement is legally justified, like a lawful arrest, then it's not false imprisonment.
Which leads us nicely into defenses, I suppose.
It does indeed. But first, maybe a quick revisit to intent. It's so central.
Yeah, let's circle back to intent for a second. We said purpose or knowledge with substantial certainty. Can you unpack that difference a bit more? Purpose versus knowledge.
Sure. Purpose is straightforward. The defendant acts with the specific goal or desire to cause the confinement. They want it to happen. Locking a suspected shoplifter in an office is purposeful confinement.
Okay.
Knowledge with substantial certainty is a bit different. The defendant might not want to confine the person, but they know their actions are practically guaranteed to cause it.
Like the example you gave of setting off a device in a small space. They might intend chaos, but no confinement is virtually certain.
Exactly. They foresee the confinement as an almost inevitable consequence of their intended action. It's more than just knowing it might happen or that there's a risk. It has to be substantial certainty. It's a high degree of knowledge.
So it's a higher bar than just being negligent or reckless about whether someone gets confined.
Much higher. Intentional torts require that specific state of mind regarding the outcome.
And motive doesn't matter for proving intent itself, even a good motive.
That's right. Angela's notes confirm this. Even if the defendant thought they were acting for the victim's own good or to prevent some greater harm, if they had the purpose to confine or acted with substantial certainty that confinement would result, the intent element is met.
The good motive might come in later as a defense, maybe.
Precisely. Like necessity. but it doesn't negate the initial intent required for the tort itself.
Okay, now the really interesting one, transferred intent. How does that apply here?
Yeah, transferred intent. It's a classic torts concept. Angela's notes confirm it applies fully to false imprisonment, just like it does to battery, assault, etc.
So the idea is your bad aim doesn't save you.
Basically, yes. If you intend to commit an intentional tort like false imprisonment against person A, but you accidentally end up committing that tort against person B,
Your intent jumps from A to B.
the law treats it that way. Your intent to confine A is transferred to B, making you liable to B for false imprisonment.
Angela's notes had that example of the punch, right? Aim for the bartender, hit the waitress.
Exactly. Intent to batter the bartender transfers to the waitress. Same principle applies if you intend to lock up person A, but accidentally lock up person B instead. Liable to B.
So intent follows the tortious act, even if the victim is unintended. But what if the original act wasn't tortious?
Critical limitation. Angela's notes make this clear. Transferred intent does not apply if the initial act was lawful.
Like the hunter example. Lawfully shooting at a deer accidentally hits a person.
Correct. Shooting the deer was lawful, not an intentional tort. So there's no tortious intent to transfer. It prevents the doctrine from applying to accidents arising from perfectly legal activities. The initial act has to be aimed at committing an intentional tort.
Okay, let's dive deeper into the methods of confinement. We mentioned physical barriers and force. Using your own body counts as force.
Absolutely. Blocking someone's path with your body, holding them down, or even just surrounding them menacingly can be physical force.
And it can be force against family or property, too.
Yes, if it effectively prevents you from leaving. Force against your child to keep you there, or physically holding your car keys or blocking your vehicle. It's about rendering escape practically impossible through physical means. Angela's notes also group confiscating essential items like crutches here as it physically prevents movement.
Right. What about distinguishing direct versus implied threats? How strong does an implied threat need to be?
A direct threat is explicit. Move, and I'll shoot. An implied threat comes from the context, the actions, the situation.
Like taking the glasses or clothes we mentioned.
Exactly. The implication is leaving without those essential items would be unreasonably dangerous or humiliating. The victim has to reasonably believe the threat, whether explicit or implicit, will be carried out if they try to leave. But remember the objective standard.
Right, not based on the victim's hypersensitivity.
Correct. It must be a threat a reasonable person would perceive as a genuine restriction on their freedom.
And the invalid use of legal authority, false arrest. What makes it invalid? Lack of warrant, lack of probable cause.
Both, potentially. It's when someone claims legal authority to detain, but doesn't actually have it under the circumstances. A civilian pretending to be an officer, or a real officer acting without a valid warrant or probable cause where one is needed.
And Angela's notes connect this directly to the defense of lawful arrest.
Yes, they're two sides of the same coin. If the arrest is unlawful, the detention is false imprisonment. If the arrest is lawful, it's a complete defense.
Okay. And the breach of duty to release, that's confinement by omission.
Right. If there's a duty to let someone go or help them move, failing to do so can become false imprisonment. The hospital example, or a caretaker refusing to help someone with mobility issues leave a building, the inaction becomes the confining act.
And the embarrassment confinement requires severe public humiliation.
Very severe. Objectively offensive to a reasonable person. The nude in public example is illustrative. It's why feeling pressured to stay and clear your name isn't enough. It lacks that extreme, objective, public disgrace element.
Got it. And finally, fraud or coercion.
Yeah.
Tricking someone into staying.
Or pressuring them so intensely they genuinely believe they can't leave. Falsely telling someone the only exit is blocked or dangerous. Or using psychological tactics to overwhelm their will. The key is that the fraud or coercion effectively removes their reasonable ability to leave.
Okay, moving to the bounded area characteristics. It has to restrict movement in all directions.
Yes, absolutely complete restriction. If there's any reasonable way out that the plaintiff knows about or should know about, it's generally not considered bounded.
Even if the way out isn't the preferred route.
Even then, as long as it's a reasonable means of escape.
But what if the only escape route is unreasonable? Dangerous. Humiliating.
Then it doesn't count as a means of escape. Angela's notes are clear. If escaping involves unreasonable risk of physical harm, serious property damage, or that severe public humiliation we discussed, it's not considered a valid way out.
So having a jump out a second-story window wouldn't negate the confinement.
Generally not. The law doesn't require you to risk life or limb or suffer profound indignity to escape unlawful confinement. The escape must be reasonable under the circumstances.
And the size of the area doesn't strictly matter. A town could be bounded.
Less relevant than the completeness of the confinement. Angela's notes confirm, yes, even a town or state could be a bounded area if all exits are truly blocked, like in a strict quarantine. But again, not usually a whole country.
So, to summarize what's not confinement, being stopped from entering a place.
Right. Exclusion isn't confinement.
Moral pressure or just persuasion.
Not enough.
And future threats or threats just a reputation.
Usually don't count either, as they lack that immediate physical restriction.
What about duration? Does it have to be for hours or days?
Nope. Duration is pretty much irrelevant, according to Angela's notes, as long as it's for any appreciable length of time.
Any appreciable length. So even a minute, a few seconds.
Potentially, yes. Even a very brief unlawful confinement can be enough to establish the tort. The violation of liberty itself is the harm the tort addresses, regardless of how long it lasts.
Okay, so if false imprisonment is established, what about damages? What can the victim recover?
Well, even if there's no physical injury or monetary loss, Angela's notes say nominal damages can be awarded.
Like a symbolic dollar.
Exactly. To recognize the legal right was violated. But if the conduct was worse, malicious, really outrageous,
Then
punitive damages might be available. These are meant to punish the defendant and deter others. Angela's notes stress these can be significant even if actual harm was small, depending on how bad the defendant's behavior was.
and emotional distress.
Yes, you can recover for emotional distress, fear, anxiety, humiliation caused by the confinement.
Does that depend on being aware?
Good point. Remember the awareness or harm element. If you weren't aware, you generally need to show actual harm, which includes emotional distress, to recover anything. If you were aware, you might get nominal damages even without proving significant distress, but proving distress would increase the compensatory damages.
All right, let's shift to defenses. What if the person agreed to be confined? Consent.
Consent is a huge one. If it's valid, it's a complete defense. It means the imprisonment wasn't false.
Can be express or implied.
Yes, express is saying yes, signing a form. Implied is through conduct, like getting on an amusement park ride or going through airport security. You implicitly agree to the temporary expected confinement.
But there are limits, right?
Oh, absolutely. Angela's notes list several. Consent obtained by fraud doesn't count.
Like being tricked.
Right. The person also needs legal capacity to consent. Minors or those with certain mental incapacities might not be able to.
What if they agree to 5 minutes but get held for an hour?
Then the consent is exceeded. The defense only covers the scope of the consent given. Holding someone longer or under much worse conditions than agreed negates the defense for that excess part.
And it has to be voluntary. No coercion.
Definitely. Implied consent isn't valid if a reasonable person would have felt forced or pressured into it.
Okay, next defense. Shopkeeper's privilege. This lets stores detain suspected shoplifters.
Yes, but under strict conditions. Angela's notes lay this out. The merchant must have a reasonable belief that theft occurred or is occurring.
Reasonable belief, not just a hunch.
Correct, based on observations. Second, the manner of detention must be reasonable. No deadly force, and force must be proportional.
Can't tackle someone over a candy bar.
Right. And third, the time of detention must be reasonable. Just long enough for a quick investigation or to call the police. Can't hold someone for hours. It's a balancing act protecting property versus liberty.
Makes sense. How about lawful arrest?
The classic defense. A valid arrest by an officer or sometimes a citizen under the proper legal authority is a complete defense.
With a warrant is clearest.
Yes, a valid warrant usually provides clear authority. Warrantless arrests have more rules. Angela's notes mention the difference between felonies and misdemeanors. Generally, police need probable cause for a felony arrest. For misdemeanors, it often has to be a breach of peace committed in the officer's presence.
And private citizens, can they arrest?
Sometimes yes, but the rules are often stricter, especially for misdemeanors. And again, reasonable force is always the limit.
What about mistakes by officers? Honest mistakes.
Angela's note suggests that a reasonable mistake by an officer, maybe about probable cause or relying on a warrant that turns out faulty due to a clerical error they didn't know about, can sometimes still make the arrest privileged for tort purposes. It protects officers acting reasonably and in good faith.
Okay. Parental discipline. Parents can confine their kids, right? Like grounding.
Yes, parents have a privilege to use reasonable force or confinement for discipline. The key is reasonable. Courts look at factors like the child's age, the behavior, and importantly, the fact that it's a parent doing it.
Why does being the parent matter so much?
Because parents are presumed to act in the child's best interest and know their child. What's reasonable for a parent might not be reasonable for a stranger.
Necessity, like confining someone to prevent a bigger disaster.
Yes, that can be a defense. Two types here, according to Angela's notes. Public necessity. Confining someone is reasonably believed necessary to avert a serious public harm.
Like stopping a disease spread or terrorist act.
Exactly. That's usually a complete defense, no liability.
And private necessity.
That's to protect yourself or a third person from serious harm, like tackling someone to stop a suicide attempt or locking up a violent drunk person, threatening others until police arrive.
Is that a complete defense too?
It defends against the tort claim itself, but under private necessity, the actor might still have to pay for any property damage they caused while acting necessarily, unlike public necessity.
Self-defense in defense of others, using force, maybe confinement, to protect people.
Absolutely, a fundamental right. You can use reasonable proportional force against an imminent threat. A reasonable mistake about the threat is usually okay.
What about deadly force?
Only if you reasonably fear loss of life or great bodily injury. And Angela's notes are clear. Never use deadly force just to stop a fleeing misdemeanant. Force must match the threat.
Okay. Recapture of chattel or land. Getting your stuff back.
Limited privileges here. For chattel, personal property, Angela's notes say you might have a privilege to use reasonable force if it was wrongfully taken, like theft, especially if you're in fresh pursuit. For land, using force is generally disfavored. The modern approach is to use legal processes like eviction, not self-help force, though some older rules or minority views might differ slightly.
Last one. What about the victim's own fault? Contributory negligence. Does that reduce the defendant's liability?
Big distinction here. Angela's notes explicitly state, contributory negligence is not a defense to intentional torts like false imprisonment.
Why not?
Because the defendant acted intentionally. The law doesn't want to reduce liability for deliberate wrongdoing just because the victim might have been a bit careless.
But what about assumption of risk? If the victim knew the risk and went ahead?
That can be a defense. If you knowingly and voluntarily encounter a known risk of confinement, like in certain jobs or activities you consent to, you might be barred from recovery. It's similar to consent, really. It has to be a knowing, voluntary choice to face the specific risk.
Okay, we've covered a lot of ground. So as we wrap up this deep dive on false imprisonment, here's something to think about. How might this concept of confining someone, which clearly goes way beyond just locked rooms, continue to challenge our ideas of liberty in the future, especially with technology, digital spaces, maybe even more subtle forms of control we haven't fully grappled with yet?
That's a really provocative thought. How freedom of movement translates when boundaries aren't physical. Interesting.
Well, that was definitely a deep dive into the complexities of false imprisonment. Huge thanks to Angela for her incredibly thorough torts notes.
Absolutely. We really appreciate Angela sharing her outlines. It allows us to, hopefully, bring these concepts to you in a clear and helpful way.
Now, just a bit of important housekeeping before we sign off.
Right. First, remember, Angela is a student preparing for the bar, just like many of you might be. She's not an expert yet, hasn't passed the bar.
And importantly, neither Angela nor this deep dive is giving legal advice. Please don't take it that way. This is for educational purposes.
And AI, like us, isn't a substitute for your own hard work studying the law.
Definitely not. And speaking of AI, we try our best, but we can make mistakes.
We're not perfect. Angela does try to catch any errors, but always double-check things yourself. It's good practice.
And if you are driving, the most important thing is safety.
Yeah.
Please focus on the road. Don't cause a tort while listening to torts.
Yeah, good one. Be safe out there.
Quick reminder on contacting Angela for podcast questions or feedback. It's podcast@studyforthebarinyourcar.com.
And for attorneys needing freelance law clerk help research, writing, etc., it's hello@legalwriterandlawclerk.com.
Okay, and now, as tradition dictates, a cheesy joke.
Oh boy. Okay, let's hear it.
Why did the Scarecrow win an award?
I don't know. What?
Because he was outstanding in his field.
Right.
This is Claude and Ma, your AI bot signing off.
See you on the next deep dive. Goodbye and thank you.